to say that I support religious freedom. And if I had to venture a guess, I would guess that almost everyone in this room, if not every single person in this room, supports religious freedom. I support the First Amendment of the United States Constitution. I support Article 1, Section 3 on religious freedom in the Maine Constitution. I even support the title of the bill, an act to protect religious freedom. What I do not support is this bill. Bill titles do not become part of Maine law. I do not cast my vote based on the title of a bill. I cast my vote for the contents of the bill, for this is the part that will be entered into Maine law. The First Amendment of the United States Constitution states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. When our founders drafted the Constitution, religious freedom and equality were lofty ideals, but not reality. There was no equality for women or poor people or people of color. Religious freedom may have been extended to people's rights to worship and congregate, but certainly not to politics or jobs. Many people may not realize that when the First Amendment was enacted, it applied only to laws passed by the U.S. Congress. State and local governments could abridge the free exercise of religion as long as there was no similar provision in their state constitution. In South Carolina, in Georgia's original constitution, it stated that only men of the Protestant religion were eligible to sit in the House of Representatives. In Maryland, it wasn't until 1828 that Jewish Americans were eligible as candidates to the legislature. Growing up in a very poor Irish Catholic family in Portland, my father was a paper boy. One of his roots was the very exclusive West End. Hundreds of times I heard the story about his grandmother warning him that if he wanted to keep his job, if he ever met a person of a certain privileged religion on the sidewalk in the West End when he was delivering his papers, that he was to immediately get off the sidewalk and walk in the gutter until the person had passed. He also told me about signs for job openings hanging in shop windows saying Catholics need not apply. This was in the 1940s. Over the last 200 years, people in both Maine and the nation have fought hard to extend religious freedom to all denominations. I do not want to roll back any of the protections and advances we have made in religious freedom. I admire the integrity and the belief of the sponsor of this bill and those who support it, and I do not question their motives for this bill, but we differ in our opinions. I see this bill as a step backwards. I see this bill filled with unintended consequences. I see this bill being used as a vehicle for a few extremists to hide behind the words religious freedom as a way to circumvent our anti-discrimination laws. And I see this bill as being used as an end run around the Maine Human Rights Act. One of the biggest reasons we uncovered during the public hearing on this bill was that people did not know what their rights were under Maine law. We had people say that they were denied being able to wear a cross necklace at work, or a child was denied bringing a Bible to school. They are protected. They are allowed to do this. A child can bring a Bible to school. You can wear a cross necklace to work as long as necklaces are allowed with others. People need to know their rights. This bill, the Religious Freedom Restoration Act, would not give them any more rights. It would only give them really a cause of action in court. So the background, what happened on this religious freedom bill, the Religious Freedom Restoration Act? Why has this been going on? To answer this question, we must go back to 1990, to the case of the Employment Division versus Smith. Smith was a member of the Native American Church and also employed as a counselor in a private drug rehabilitation clinic. He was fired from the clinic for illegal possession of the drug peyote. He applied to Oregon's Unemployment Division for unemployment benefits. His claim was denied because he was dismissed for work-related misconduct for drug possession, being a drug counselor in a drug addict clinic. He brought suit claiming that Oregon's drug law prohibiting the consumption of illegal drugs for sacramental religious violated the Free Exercise Clause of the Constitution. In the majority opinion, written by Justice Scalia, the U.S. Supreme Court held that neutral laws of general applicability do not violate the Free Exercise Clause of the First Amendment. Justice Scalia wrote, quote, "To permit this would be to make the professed doctrines of religious belief superior to the law of the land, and in effect to permit every citizen to become a law unto himself." The compelling government interest requirement seems benign because it is familiar from other fields, but using it as the standard that we must meet before the government may accord different treatment is not remotely comparable to using it for the purpose here. What it would produce here, a private right to ignore generally applicable laws, is a constitutional anomaly, end quote. After this decision, a very broad coalition of people got together, including the ACLU, who now opposes this bill, and said that they wanted to restore the compelling interest argument. What happened later was in 1993, Congress passed the Religious Freedom Restoration Act. Here, I'll call it RFRA. RFRA, the purpose of this law was to restore the compelling interest test. This happened. But 4 years later, in 1997, another decision by the U.S. Supreme Court held that the RFRA statute applied only to the federal government, and Congress did not have the power to levy it against the states. It's now been 17 years since this 1997 decision, and during this period of time, 18 states have adopted some form of the federal RFRA, which means that 32 states have not adopted it. In fact, many states have rejected this bill, and the trend is away from adopting this bill. While the ACLU may have fought in 1993, they've had 21 years of hindsight and have seen the unforeseen consequences of this bill and are adamantly opposed to it. So why don't we need this bill? Religious freedom is protected in Maine under the Constitution, and there was no evidence given that Maine's existing religious protections were not working. Religious freedom is explicitly protected under the Maine Human Rights Commission. There are 34 religious exemptions in Title V, Maine law, that protects religious freedom in everything from property taxes, immunization, school absences, smoking, polygraph tests, highway signs, food safety, workers' compensation, prisoners' rights, alcohol, and drug testing, just to name a few. Plus, under Title 22, Health and Welfare, Maine has 2 statutes that protect physicians, nurses, healthcare workers, and others from having to perform or assist in any act pertaining to an abortion. Many people mistakenly believe this bill will allow the manger scene back in front of City Hall or any other religious display. It will not. This bill does not make any specifics at all. What it does is give you a cause of action, a greater cause of action to sue the government for any law, bill, or ordinance that they do. So why now? What has happened to bring this forward? Over 17 years. I don't know, but I do know 3 facts. The first one is that although the first state passed a RFRA statute 17 years ago, according to research in our law library, this bill has never been introduced here in Maine. I also know, too, that in 2012, same-sex couples won their freedom to marry by changing Maine law through the Citizen Initiative ballot process. The third fact I know is that in 2012, the Affordable Health Care Act was passed by Congress, and a ruling was made which required health plans to cover contraceptives. To date, 90 cases have been filed by people in states with RFRA to challenge this ruling under the Affordable Care Act. The Hobby Lobby case is the test case. This case is currently, right now, before the United States Supreme Court, and oral arguments are scheduled on March 25th. This is a case where the owner of a company is using RFRA and his religious freedom to deny contraceptive coverage for his 13,000 employees. Maine should not pass anything until this case is decided. Since this bill was never introduced prior to 2012, it makes me wonder if this bill is really about religious freedom, or is it about trying to erode the existing women's rights and gay rights that we have fought so hard for? We cannot use religious freedom as a vehicle to circumvent Maine's strong anti-discrimination laws. Maine has a history of working hard to strike a balance between religious freedoms and the right to equal protection under the law. We have a strong Human Rights Commission to uphold the Human Rights Act, and we have strong Maine case law on well-defined facts. There's over 10,000 religious dominations in the world, with 50 to 100 known ones in Maine. According to survey results in a Portland Press Herald article, actually 70% of the people in Maine don't identify with a certain religion that they have. If we pass this bill, what rights to the people that don't identify with a religion? What rights will people then have if they suddenly decide to identify with a religion because they want certain protections? I need to end with an email that I just received yesterday, and he writes, quote, "As a Christian minister, I'm offended when religion, any religion, is used as an excuse to deprive others of their rights as human beings. We need to send a message to those who would do so, that in the state of Maine, legalized bigotry will not be tolerated," unquote. He was urging me to oppose 1428. And I, along with this minister, also urge you to oppose LD 1428. Thank you.